Ew. Who? I went to the dentist today, and that was not fun. So, pardon me if I start slurring or something of the sort. It's not because of my cabinet. It's because half of my mouth is still numb. Yeah, so I've had a fun day today. How your day been? Oh, I I went in for. I thought I lost. What do you call it? Fixing. Yeah, whatever. Because I felt okay. Something's off here. As it turns out, my wisdom tooth cracked in half. Yeah, yeah. Fun times, fun times. So I was, but my dentist is no BS, none of that. Oh, you need to take better care. Well, of course, she does, but none of that over excessive bullshit. Let's take care of it. And she numbed me up. Well, she took the photo and X-ray and stuff like that. And she just said, yeah, I'm going to yank it. All right, here we go. And numbed half my face. And then, now, she's like, on a good day in heels, she's 5 foot and 100 pounds. But when she and she grabbed and pulled half my face off, more or less, and yanked, and yep. So now I don't have a wisdom tooth anymore. So that's fine. And it didn't hurt. My dentist is one of the good ones. And then it was just, yeah, all right, pay up front. When we will see you next time. Well, aren't you going to check the rest of my mouth? Nah, you know your mouth. But come here. You come here when you hurt. Come a little bit more often. That's about it. So no bullshit. Paid. Off I went, and I was planning on going live with this at maybe 4, but half my face is still numb. Now only half my mouth is still numb. So let's do this. Oh, hello, Kristen. Thank you for being a member for 5 months. Let's go. Yeah, this is a case I've been covering for almost a year now. The Michigan Hyperbaric chamber explosion case, which ended the life of 5-year-old Thomas Cooper. The people charged are the CEO of the company and 3 employees. This is a hyperbaric chamber treatment center. And they claim to treat ADD, sleep apnea, and autism, all the letters, all the letters they claim to treat with this hyperbaric chamber. A hyperbaric chamber is also more commonly seen in diver situations. For instance, if you are a diver and you ascend too fast, you have to go into one of these to be repressurized, so your blood doesn't screw you up. Now, the hyperbaric chamber treatment is they pump it full of 100% oxygen, and then they pressurize it. And Thomas Cooper was there because severe ADD, sleep apnea, and this place claimed they could treat him. He had been there a few times before. This time was different. a spark ignited, and the chamber burst in flames. In a hyperbaric chamber with the pressure, all the oxygen is pressured into every pore of your body. So when that exploded, the entirety of little Thomas Cooper caught fire at once. His mother got severe burns on arms and chest when she tried to save her boy. So that is the case. So yeah, it's, and as they found out, I've been covering this case. I have about a dozen videos and streams about this case. In a hyperbaric chamber, if you use 100% oxygen, you should be having one of these grounding bracelets that grounds you so there won't be a spark. This facility didn't use that. They found unused grounding bracelets in one of these junk drawers. They also, according to the prosecution, the chamber they are talking about exceeded the maximum limit of sessions, which is 20,000. At that point in time, the manufacturer says we can't service this anymore. But they kept using it. They kept using it. So, today is the final hearing. We have had pre-trial hearings, or to be exact, we have had probable cause hearings since, I believe, March of last year. Because it is a complicated case with a lot of electronics, and everything in this specific hyperbaric chamber blew up, which means it has taken time for the investigators to check what exactly happened. So we have listening to fire marshals. We listened to we listened a few videos ago. We listened to the representative of the manufacturer of this hyperbaric chamber, and let's just say it was interesting to listen to somebody who was trying to help and at the same time not expose the company for a civil suit. I don't think he did a good job. Let's just say that. But this is it. And for the 2 or 3 who shows up every now and then and say, why are you always saying these female judges are so bad? Well, first of all, I've been saying bad things about judges regardless of gender. If you don't believe me, 2 damn years of the YSL trial and Judge Glanville, the judge in the Zachariah Anderson trial. Now, since then, we had Judge Bev, Judge Gull, and now the Judge Lott in the Faust trial. Let me present to you what I believe is a good judge. All right, are you ready? Here we go. Oh,
Yes, of course. All right, can you hear me, Mr. Gleason and Mr. Kramer?
Yes, Your Honor, we can. Thank you very much.
Okay, thank you. So let me call the cases here, and we can begin. This is 2500877, the people of the state of Michigan versus Alita Moffett.
Thank you. Good afternoon, Your Honor. Chris Kessel for the people.
Good afternoon, Ellen Michaels on behalf of Alita Moffett, who is present in court to my right, state your name. Alita Moffett.
Thank you. I'm just going to call these individually today. This is 2500878, the people of the state of Michigan versus Jeffrey Allen Mosteller.
Chris Kessel for the people.
Good afternoon, Your Honor. Alona Shawn on behalf of Mr. Mosteller, who is standing behind me. State your name correctly.
Jeffrey Allen Mosteller.
Thank you. 2500875, the state of Michigan versus Gary Markin.
Chris Kessel for the people. Good afternoon, Your Honor. Todd Flood and Edward Gold on behalf of Mr. Markin, who is to our left and right, respectively. If you could please state your name for the record. Gary Markin.
Good afternoon, Your Honor. Hannah on behalf of Mr. Gary Martin.
All right. And then I have 2500876, the people of the state of Michigan versus Tamla Peterson.
Thank you, Judge. Chris Kessel for the people.
Thank you, Your Honor. Elise Lisby on behalf of Ms. Peterson, along with my colleagues, Tom and Sherry. I don't know if they want to.
yeah. This is the CEO that he's representing, who is standing up behind. She got she posted bond, but with limitations, as in house arrest. And she has been whining ever since. Oh, poor me, poor me. Oh, I need to do this and that. Oh, poor me, poor me. At the same time, she violated the bond at one occasion by being present or with a gun. Now, that in itself, yeah, it's kind of stupid, because just because she is on bond, why, and her husband, partner, whatever's, his gun was at, I believe it was at the gun range in a locker, but courts in Michigan seems to believe that that is having access to. So she got herself one night in jail, and then she was back on bond. Hey, Dave. How are you doing? Dave is a Michigan attorney. So, hey, if you have time, Dave, if you have time, I'll send you a link. Since Dave is local, he can explain maybe a bit more about these things. All right, let's continue.
Please, yes, please place your appearances on the record.
Your Honor, thank you. Tom Kramer appearing via Zoom on behalf of Ms. Peterson.
Gerald Gleason on behalf of Ms. Peterson, Your Honor, as well. Thank you for allowing.
Oh yeah, and Miss Peterson, when arrested, she, in her possession was foreign currency and a bunch of interesting stuff. And allegedly, she has a fuck ton of money, because this is not her only hyperbaric chamber treatment facility. And yeah, it's apparently very, very profitable to run a facility with safeguards not in place.
To participate via Zoom.
Yes, and to the extent that I understand, Ms. Peterson is aware that her attorneys were going to be appearing via Zoom today. I'm assuming she has no objection just for today's hearing. Is that correct?
Yes.
And could you state your name for the record?
Tamla Peterson.
Thank you. I appreciate that. So today is the date and time we have scheduled for the court to issue an opinion on its decision relative to binding over the matters that were before the court as to each of the defendants. Clearly, everyone is aware of the procedural history of the case, so I don't need to add anything to the record. I simply intend on issuing my decision today. I will put everyone on notice that you can stay seated because it's probably going to take me a little bit of time to place my opinion on the record. I have written it out, but I intend to read it into the record today. And I think it's appropriate to do that. And I hope the fact that it's a little bit lengthy is not lost on anyone, the amount of time that we've spent on the case and the detail that I think needs to be placed into the record. So at this time, unless there's something else that we need to address, my intention is to simply issue the opinion by reading it into the record. Was there anything else we needed to address at this time?
Not from the people.
Nothing on behalf of the board.
All right. So the law establishing the people's burden at the preliminary exam is clear. In general terms, the purpose of the exam is to determine whether a crime was committed and whether there is probable cause to believe that the defendant committed it. More specifically, in order to bind a defendant over for trial in the circuit court, the district court must find probable cause that the defendant committed a felony based on there being evidence of each element of the crime charge or evidence from which the elements may be inferred. Probable cause requires enough evidence to cause a person of ordinary caution and prudence to conscientiously entertain a reasonable belief in the defendant's guilt. And I'm citing People versus Crumbly, 346, Mich. App 144, page 167, 2023. The law is equally clear as to both the duties and limitations placed upon the judge presiding over the preliminary exam. The judge has, quote, the duty to pass judgment not only on the weight and competency of the evidence, but also the credibility of the witnesses and may consider evidence in defense. This is citing People versus King, 412 Mich. 145, page 153. If the judge believes that evidence contradicts as to the elements of the charged felony offense, the law does not allow the district court judge to resolve these conflicts at the preliminary exam stage. Quote, if the evidence introduced at the preliminary examination conflicts or raises a reasonable doubt about the defendant's guilt, the judge must let the fact finder at trial resolve these questions of fact, and this requires binding the defendants over for trial, citing People versus Hudson, 241, Mich. App 268, page 278, 2000. Today's decision comes after considerable time and attention has been given to all of the evidence presented, which includes over 7 days of testimony, filling almost 1,900 pages when transcribed, hundreds of pages of exhibits, dozens of photos and videos capturing events leading up to and including the death of Thomas Cooper. 3 defendants, Tamela Peterson, Gary Markin, and Jeffrey Mosteller, are charged with second-degree murder and involuntary manslaughter in the death of Thomas Cooper. Quote, Michigan courts have commonly recited the following 4 elements of second-degree murder: death caused by the defendant, with malice, and without justification or excuse, citing People versus Spears. The death of young Thomas Cooper on January 31st, 2025 in the city of Troy, Michigan satisfies the first element of second-degree murder well beyond a probable cause standard. To establish that there were acts perpetrated by Peterson, Markin, and Mosteller that ultimately caused Thomas's death, the people presented evidence to show that the defendants actively participated in the decision-making and enforcement of a mandate that all patients of the Oxford Center in Troy, including Thomas Cooper, could not wear a key safety component, the wrist grounding strap, when receiving treatment at the facility. Unlike the picture painted by Ms. Peterson's attorney at the conclusion of the hearing, the testimony during the hearing did not support the idea that Peterson was an aloof, isolated CEO removed from day-to-day operations of the business. To the contrary, Peterson was described during testimony as personally and professionally involved in every decision that was made at both centers during the time that the business was operating. There were a wide range of responsibilities that the evidence indicated she was responsible for, from ordering polyester pillow filling to modifying safety protocols to communicating with Seacrest regarding repairs and service, including to inform them that the annual maintenance that should have been completed on the chamber that Thomas Cooper died in was no longer needed because the machine was reportedly, quote, sold and replaced, from People's Exhibit 10. Bowen Yang, an Oxford Center employee from 2015 to 2025, described the decision-making process at the center as one that often involved Ms. Peterson taking information from others, specifically Mr. Mosteller, to make decisions. Tiffany Hosey, when asked about the hierarchy of authority at the Oxford Center, testified that Tammy Peterson was at the top, approving every decision that was made. She testified that Gary Markin fell just underneath Peterson, describing him as Tammy's, quote, right-hand man. Jeff Mosteller was described as third in command, likely because he came to work at the center more recently. The notion that Mrs. Peterson was the only person that had authority in the organization was simply not supported by the evidence. The employee witnesses independently testified about their experiences working at the center. Many of these experiences demonstrated that either Gary and Tammy, Jeff and Tammy, or some combination of all three were involved in decisions regarding treatment, safety, facilities, equipment, training, and managing employees at the center. Their testimony also supported the notion that these defendants received training themselves in hyperbaric medicine and throughout the years provided patient care and operated the chambers. Although Mr. Markin also appeared to have several property management responsibilities, there was sufficient evidence presented to establish that he also had a high level of authority in the organization over the time that he worked there, and that he had undergone training to understand industry standards for operating the machines and treating the patients. Witness testimony established that Jeff Mosteller was brought on specifically to ensure that the center had a designated safety director. By all accounts, Mr. Mosteller appeared to be qualified for this role based on his own training and experience. Testimony from former employees supported the people's position that he was actively engaged in business operations, including training employees and others outside of the center on industry standards and risks associated with hyperbaric treatments. To establish causation, the people went to great lengths to educate the court on the science behind hyperbaric treatment and the volatile environment created within the monoplace chamber. Two experts were presented by the people possessing a vast array of knowledge on the mechanics of the chamber, the treatment process, and the safety requirements that were mandated and are mandated by the industry. Francois Berman was qualified as an expert, possessing more than 50 years of experience, a high level of education, and international certification as an engineer. He has reportedly taught courses in hyperbaric chamber safety since 1997, is a highly regarded member of UHMS, and quite literally wrote the book on hyperbaric safety with his contributions to Chapter 14 of the NFPA 99. Berman's testimony was the first opportunity that the court had to consider the necessary elements required to create the fire triangle: ignition, fuel source, and oxygen. Mr. Berman's testimony, in conjunction with the testimony of Andrew Malenchenko and Deputy Fire Chief Sean Hugg, probed into whether the three elements needed to complete the fire triangle existed in the chamber that Thomas was in on January 31st, 2025, and how they came to exist. Mr. Berman's written report, which is admitted as People's Exhibit 6, identified a significant amount of obvious burnable fuel in the form of patient clothing, cotton blanket, cotton pillow cover, polyester pillow filling, cotton mattress sheet, mattress cover, and foam. His testimony expounded on the significance of burnable fuel placed into the chamber on the day that Thomas was treated. Both experts testified about the risks associated with using dissimilar materials near each other inside a chamber, which would create friction if there was movement of the materials against each other, increasing the potential for a static discharge. The investigation led to the discovery that dissimilar materials were likely in the pillow casing and the pillow filling used at the Oxford Center in Troy on the day of the fire. Videos capturing Thomas's treatment on the day he died showed his significant movement about the pressurized chamber, a factor that the experts testified increased static and the likelihood that a shock would occur. The investigation revealed that employees were told to follow other concerning practices and had done so on the day that Thomas died, including providing warm blankets to the patients directly from a dryer in the chamber suite. Berman raised several other concerns about the chain of events that he viewed on the videos. In addition to the obvious lack of a grounding strap on Thomas, Mr. Berman noted a lack of any effort to confirm grounding of the machine prior to treatment with a multimeter. Mr. Berman, as did others, concluded that there was no physical safety check conducted of Thomas's person, despite both experts' opinions that a physical safety check was the industry standard, rather than verbally confirming the patient had complied with the safety requirements. People's Exhibit Number 7, the CV and final incident report of Andrew Malenchenko, Technical and Safety Director of Hyperbaric Medicine at the Mayo Clinic in Rochester, Minnesota, provided a succinct and powerful summation of what the investigation uncovered. Quote, "This incident is a tragic example of the need for hyperbaric facilities to set and maintain the codes set forth by the National Fire Protection Association and follow the instructions from the chamber manufacturer. It is my view that this incident could have been avoided if a high impedance grounding wrist strap were worn, along with the proper textile control and pre-treatment verification of patient grounding, end quote.
Yes, what the defense of these four charged brought as an excuse for not using the grounding bracelet. Well, a grounding bracelet has a cord, and if they move around a lot, they can strangle themselves. That was their excuse. That didn't land well with me. In my opinion, if that is your concern, why are you putting kids in there? The answer, in my opinion, profit. If you fool parents into believing that this temporary oxygen pump can actually cure sleep apnea, ADD, and other things, yeah, this case pisses me off because everything about this was avoidable by a $2 wrist grounding bracelet.
Ultimately, the combination of former employee testimony about how safety decisions were made and the scientific testimony of the experts as to causation established the second element of second-degree murder to a probable cause standard. Even as the court reaches this conclusion, however, it cannot be ignored that there were areas where the evidence conflicted. On the element of causation, the defense attorneys collectively argued that the deputy fire chief's report was not scientifically accurate because the deputy chief acknowledged that some analysis was not completed at the time that the report was issued. The inconsistencies in this testimony solidified this court's belief that there remain questions of fact that must be left for the trier of fact to decide. The lengthy examination of witnesses led to other evidence of questionable practices under the supervision of Peterson, Markin, and Mosteller. All three former employees reported that it was standard practice for 1 or 2 techs to manage between 5 and 8 chambers at a time, in direct violation of the state safety standards that recommend that no more than 2 patients are overseen by 1 tech. Even though employees reported working at the facilities for years, sometimes logging 8 to 10 hours a day when they worked their shift 5 days a week, the evidence was still not clear as to who the medical director was at any given time. Based on the testimony, it reportedly changed often, and the medical director was rarely on site. There was conflicting evidence about who was responsible for training employees, who provided the medical clearance, what safety checks had to be conducted on the machine and or the patient, and who was servicing the machines and for what purpose.
Folks, hey, I do labor and employment law. If there are uncertainties in whose responsibility a certain task is, you go up a level and up a level. And Ms. Peterson, the CEO, it was her responsibility. So if there are uncertainties of who did what, it's because of her leadership. I would guess the reason why they had issues keeping actual medical staff there was because they were selling snake oil with a revolving door, people in, people out. So people quit, especially people with a medical degree. She didn't care. She made money selling snake oil.
To the extent that these additional safety concerns and unclear practices of the center contributed to the likelihood that a fire would take place during the treatment and that these defendants should have known this, the trier of fact is best suited to evaluate any inconsistencies in this evidence. To prove the third element of second-degree murder, the prosecutor must also establish that the acts committed by the defendants were done with malice. Malice is defined as, quote, the intent to kill, the intent to cause great bodily harm, or the intent to do an act in wanton and willful disregard of the likelihood that the natural tendency of such behavior is to cause death or great bodily harm, citing People versus Goecki, 457, Mish 442, page 464, 1998. Because depraved heart murder, the theory in which the people proceed in this case, is a general intent crime, the accused need not actually intend the harmful result. The mens rea or state of mind required for second-degree murder, quote, does not mandate a finding of specific intent to harm or kill. The intent to do an act in obvious disregard of life-endangering consequences is a malicious intent. Again, citing People versus Goecki from page 466. In considering whether the people established the element of malice to a probable cause standard, the court carefully considered all evidence that showed or inferred what the defendant should have known, what they demonstrated they knew, and the resulting actions they took with the information they possessed. On day one, Tiffany Hosey testified about taking safety concerns to both Tammy Peterson and Jeff Mosteller over the center's policy prohibiting the use of the grounding wrist strap. She took these concerns both in person and in writing. In response, Tammy and Jeff told her that their own independent testing proved to them that the straps were not needed. Tammy reportedly made attempts to give credence to this decision by claiming that she did not want to use them because they could be a choking hazard for the children. Neither expert believed this to be a valid or likely scenario that would arise or justify discontinuing the use of the strap for all patients. Ms. Hosey's testimony also confirmed that Gary Markin was both aware and supportive of the decision to treat patients without the industry-mandated use of the strap. He was reported to have taken part in Ms. Hosey's final meeting at the Oxford Center, in which Tamela Peterson allegedly informed her that she was uneducated and ill-informed based on the safety concerns that she raised. Gary Markin took this opportunity as Hosey was being fired to again attempt to justify the center's practices by telling her that the grounding strap was not necessary for patient safety, claiming the patient was considered grounded simply because the chamber was grounded. Hosey's testimony was a chilling reminder of the authority wielded by Peterson, Markin, and Mosteller over employees, as it clearly showed what the potential outcome could be for an employee that attempted to challenge the way that the business was operating. Andrew McMullen testified about the knowledge that the defendants had about the dangerous conditions inside the chambers at their own center that were often visible to the techs administering the treatment. McMullen testified about the shock that he received when he was cleaning the chamber. He testified that he shared this information with Tammy directly, as it caused him concern when coupled with the independent observations that he had made of small children receiving treatment in the chambers. He reported seeing the children's hair stand up, indicating a static present in the chamber during treatment. He reported sharing these concerns because of what he learned in Jeff Mosteller's training that specifically spoke to the dangers of a deadly fire that could start from a static shock. McMullen testified that as his experience grew and he participated in additional training, he became more vocal in sharing his concerns. The concerns continued to grow with issues that came up during treatment, some of which were the result of volatile behavior of the young patients being treated through Peterson's ABA program, just like Thomas Cooper. He reported being the first person employed at the center that asked for a multimeter so that he could check grounding of the machines before treatments years after the center opened. Even after he requested the multimeter, the evidence showed that the use of this tool was never required by Tammy, Jeff, or Gary, despite the fact that the industry considered it to be an essential safety practice. McMullen described his current concerns being dismissed when he brought them up to Tammy, Jeff, and Gary. He testified that he was never given a believable answer as to why they trained based on the standards in the Secrets manual, yet failed to adhere to these practices at the center. McMullen's testimony included examples to show that many of the safety practices that Peterson, Markin, and Mosteller abandoned over time were once closely adhered to at the center. He recalled a time when the center required each patient to wear 100% cotton scrubs provided by the center before they entered into the chamber for treatment. When this practice stopped, he testified that the center continued to utilize physical safety checks to confirm that only approved fabric material was worn by the patient. these physical checks often being conducted by Tammy and Gary themselves. He testified about a significant change in procedure once they began treating an increased number of children. Children treated at the center in its earlier years were required to dive with a caregiver, but when the number of young patients grew, this practice ceased with little to no explanation as to why.
If it takes longer to get 2 people in there, you can't push as many patients. These, I believe, this facility was preying on desperate parents with kids with different illnesses, ailments, promises of easement, maybe even cures. So they eased up on the safety to treat more children. And now Thomas Cooper, age 5, is gone.
Similarly, Mr. Gang testified about the change in procedure regarding the use of the grounding strap. Gang testified that the wrist grounding straps were used with every patient when he started working at the Oxford Center in 2015, but that one day the employees were simply told they could no longer use the straps. He testified that there was no discussion on the decision, and that even with the limited experience he had working in hyperbaric medicine at that time, he felt uncertain about why this safety precaution was abruptly discontinued. He reported looking to fellow employees for reassurance that the change in practice was safe. Bowen Gang and Andrew McMillan testified about Mosteller's involvement in the testing he undertook to demonstrate that patient safety was not jeopardized by the policy at the center prohibiting the use of the strap. Mr. Gang testified that it was his participation in the test that Mosteller conducted, but more specifically the way in which Mosteller spoke to him to convince him, that led him to believe that the practice of not using the straps was safe. The evidence supported the people's theory that not only was Mosteller failing to enforce the industry safety standards at the Oxford Center in his role as safety director, but he also appeared to be actively engaging in self-serving research to support a practice at the center that was directly in conflict with the industry standard. All 3 employees testified candidly that they did not believe that the tests conducted by Mr. Mosteller carried scientific value based on the way they were conducted. Both witness testimony and documentary evidence, specifically People's Exhibits 10, 12A, and 14, support a probable cause determination that the defendants participated in conduct that demonstrated a wanton and willful disregard of the likelihood that the natural tendency of the conduct would cause death or great bodily harm. The center's own internal policy and procedure manual, getting down to the nitty-gritty, the must-have important stuff you really, really need to know in one place manual, expressed a clear understanding of the need to follow all of the industry's safety standards. The warning on page 2 of the emergency procedure policy for fire in the chamber reads as follows, quote, warning, in the event of a fire in a monoplace chamber filled with 100% oxygen, it must be noted that there is not a realistic chance that the patient inside the chamber will survive. Given this stark reality, then the bulk of operational effort must be concentrated on prevention of fire and to eliminating ahead of therapy to the greatest extent possible a fire from ever starting, end quote. The decision-making pattern consistent throughout the testimony could lead a person of ordinary prudence to believe that Tammy, Gary, and Jeff had the knowledge and capacity to implement proper safety procedures, but intentionally decided to implement procedures that were inconsistent with industry standards. Coupled with years of documented attempts by employees to raise issues relative to the use of the grounding strap, which appeared to be all but ignored, the evidence showed a continuing pattern of conscious decision-making by Peterson, Markin, and Mosteller to implement practices with willful and wanton disregard for the likely tendencies that could result, specifically taking action that increased the risk of a fire they knew a patient could never survive. This evidence supports the people's burden to establish probable cause as to the elements of malice without justification or excuse. Several cases were cited by the defense that the court reviewed in reaching this decision. Those that apply have already been cited in the opinion, but as to the others, there were 2 cases that the court felt warranted a response. In the People versus Grant and Gabriel Baylaw, the district court judge's decision to grant the defendant's motion for dismissal of the case, which was ultimately upheld by the Michigan Supreme Court, came only after the district court judge concluded that the expert's testimony weighed heavily in favor of the defendants and could not be used to support the element of malice. This is not how the court views the expert testimony in this case, and as such, Judge Hessen's articulate rationale would not apply in this case. Ms. Sharon, on behalf of Mr. Mosteller, argued in closing that this court is bound by the Michigan Court of Appeals decision in People versus Mildred and Edward Giddings. Defense counsel was adamant that the decision there served as a clear directive from that court that a failure to act or omission alone cannot support a second-degree murder charge. This court read the Court of Appeals decision to conclude something different, that either a failure to act or other omissions, so long as they are coupled with evidence of the appropriate intent, may rise to the level of second-degree murder. A recent decision in the Michigan Court of Appeals in People versus Brian Robert Morrow, which was published December 11th of 2025, clearly supports this court's reading of the Giddings opinion when that court states that, quote, when courts use the term act to describe the elements of second-degree murder, that language should not be read to exclude an omission that otherwise meets the requirements for murder, end quote. As there were both omissions and definitive acts alleged against the defendants in these cases, and this court having determined that the people met their probable cause burden as to malice, the decisions in Giddings and now Morrow certainly wouldn't preclude the court from determining that the people have established the elements to a probable cause standard. To the extent that these three defendants have been charged with the crime of involuntary manslaughter, the first two elements of both crimes are the same, that there was a death caused by an act of the defendant. To prove involuntary manslaughter, the people must also prove that in doing the act that caused Thomas Cooper's death, the defendant or defendants acted in a grossly negligent manner. While it likely requires little additional explanation as to why the evidence cited throughout this opinion as to Peterson, Markin, and Mosteller would similarly support probable cause on the people's burden to prove this element of involuntary manslaughter, the court must address the evidence as it relates to the involuntary manslaughter charge against Ms. Alita Moffitt. The evidence showed that Ms. Moffitt was the hyperbaric tech responsible for administering treatment to Thomas on the date of the fire. Ms. Moffitt was working in her capacity as a hyperbaric chamber technician and by all accounts would have been responsible for following the procedures she was trained on and those that were mandated by the NFPA 99. To establish that the defendant acted in a grossly negligent manner for exam purposes, the people must present some evidence that the defendant knew there was a situation that required her to take ordinary care to avoid injury to another. The people must also establish to a probable cause standard that the defendant could have avoided injury to another by using ordinary care. And lastly, the people must show that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it would have been apparent that the result was likely to be a serious injury. While the evidence did not show that Ms. Moffitt had obtained her hyperbaric tech certification, the record during the exam supported that Ms. Moffitt was trained as a hyperbaric tech and had been employed at the center for several years before the fire. Mr. Gang testified that he was working in the Troy location at the time Ms. Moffitt was hired and assumed some responsibilities supervising her in the manner that he himself had been trained. He testified that Jeff Mosteller had training responsibilities for employees as the safety director and likely oversaw Ms. Moffitt's training initially as well as throughout the time that she was employed at the center. Ms. Moffitt is differently positioned within the organization, to be sure, but her...
All right. For you who just joined, thank you, Dali, for the raid. This is the Michigan Hyperbaric chamber explosion case. This is the final hearing in the probable cause hearing series of probable cause hearings where the judge announces her decision if the four defendants, if there is probable cause to release this case to the circuit court. As it seems, the court has found probable cause. So now we are listening on her. She reads now into the record what the judge says. This is the foundation to the findings of probable cause. There are four defendants in the hyperbaric chamber explosion case: the CEO, Tamara Peterson, and 3 employees. December 31st, 2025. No, January 31st, 2025. Thomas Cooper, age 5, entered the Oxford Clinic in Troy, Michigan, for hyperbaric chamber treatment of his ADD and sleep apnea. A spark ignited the pressurized chamber filled with 100% oxygen, and it exploded. His mother got burns on her arms while trying to save her son. The judge here is Judge Maureen McGuinness, Troy 52nd-4 District Court. So yeah, so we've heard that how they started out this Oxford Clinic doing all the safety protocols of this, in my opinion, snake oil facility. But as the number of children grew as patients, they started lacking in safety protocol to the extent that they stopped using more or less any safety protocols in order to keep the revolving door running, ending in the death of Thomas Cooper.
Conduct is not being judged in the same manner as the other 3 defendants facing second-degree murder charges. Although her attorney attempted to argue that she did not possess the knowledge that the grounding strap even needed to be used and could not be found to be acting with, quote, willful and wanton disregard for this reason, this is not the element that the people have to prove as it relates to Ms. Moffat's actions. Her co-worker, Mr. Gang, testified that he worked with her at the very same location for several years. He described her as an excellent tech and someone that was very safety-minded and not afraid to ask questions. He said that he supervised her and attempted to train her in the manner that he had been trained. The testimony that he provided about his own training acknowledged that he was very aware of the dangerous conditions that needed to be prevented in the chamber, specifically static in the chamber that could lead to static discharge and fire. Ms. Moffat's conduct is viewed through the lens of the reasonable person, and given the great weight of the evidence presented about all of the factors that created the environment in the chamber that Thomas was receiving treatment in on January 31st of 2025, a static discharge leading to a fatal fire was a very real and possible outcome that a hyperbaric technician would have been expected to use ordinary care to prevent. There was sufficient evidence to contradict the defense's argument that Ms. Moffat was employed in her capacity as a tech, but knew absolutely nothing about the risks inherent in treating someone in a monoplace chamber. While the evidence may not convince the court today of guilt beyond a reasonable doubt, there is enough to establish to a probable cause burden that Ms. Moffat's actions on the day of the fire fell short of what a reasonable person would do to avoid the outcome that ultimately killed Thomas Cooper. The final decision must rest with the trier of fact given what has been presented. As to the charge of intentionally placing false information into a medical chart, Ms. Moffat is alleged to have entered an end time for the dive that was inaccurate. The evidence appeared to show that Moffat engaged in the practice of what is known as pre-charting, which several witnesses acknowledged was a practice that was utilized by the techs at times. Mr. Gang testified that while he understood that techs were to avoid pre-charting, this was difficult to do when they were busy. He also testified that if it had to be done, they understood that the correct information had to be updated within the chart close in time to when the expected treatment was modified. The testimony of former employees supported the notion that pre-charting was done at the center because of the volume of patients they were overseeing by 1 or 2 techs that were working at a time. There was nothing presented to the court that would lead the court to conclude that the center's accepted practice of pre-charting is an appropriate legal defense to entering incorrect medical information into a medical record simply because an unexpected fatality occurs. While the record certainly does not support an inference that Mrs. Moffett placed incorrect information in the chart to mislead in a nefarious way, it does support a probable cause determination that the information regarding the end time for Thomas's treatment was inaccurate when it was entered by Ms. Moffett because the end of the treatment had not yet occurred. To the extent defense counsel argues that Ms. Moffett does not qualify as a healthcare provider or other person under the language of the statute, this is a question of fact to be resolved by the trier of fact. While Ms. Moffett did not appear to be licensed specifically as a hyperbaric chamber technician, it's also not clear that this is even a certification recognized under the statute. There is certainly enough information to support the people's position that Mrs. Moffett was working as a healthcare provider, administering treatment to patients, and that she is the person that added the treatment information into Thomas's chart. There was no evidence to support defense counsel's claim that Ms. Moffett just took notes and another person assumed responsibility for entering info into the medical chart. Any consistencies in the testimony or legal arguments that can be made based on the evidence must be left for the trier of fact to decide. So given the court's findings after the conclusion of the preliminary exam, this court today is finding each defendant over on both of their original felony counts consistent with the ruling that's been issued on the record today. Is there anything else?
No, thank you, Judge.
The additional information about their next court date will be provided to them shortly, including the judge that they'll appear in front of, the date and time that they will appear for arraignment on the information. I don't think that at this point I have any issues relative to bond that would need to be addressed today for any of the defendants. So unless there's something else that has to be placed on the record regarding the bond, my intention is to continue it as it's currently ordered.
Thank you, Judge.
Thank you.
Thank you.
Yeah. They are headed for trial. Now, trial is with 4 defendants and this complicated case. I would be surprised if we see this trial before the end of the year. There is now all the things pre-trial will take place. This was the probable cause. Yes, there's probable cause to move this forward towards trial. So now you're going to have all the motions, pre-trial hearings, bond hearings, everything. And it will take place, I don't know, once per month, once every 2 months. Do we know if a plea offer has been offered? To my knowledge, there is no plea negotiations ongoing in this. I would be surprised if it isn't, because there are 4 defendants. And when it comes to Mrs. Moffett, I believe she has reasons to plead out for something lesser in order for a testimony. That is something I would suspect would happen. If that is offered or if it is accepted, out of my control. So, I started covering this way back when. Let's see here. Way back when. Well, okay. I started looking into it in April. I made my first stream in July. Okay. I don't have anything else for you today. Sadly, there's no trial in the Faust case today. They will restart tomorrow with the defense case, if there is one. And but yeah, once in a while, when there is an update on this case, I will let you know. And this is one of these cases that should be covered more by more people, just for the recognition of this snake oil sales thing with hyperbaric chambers, what they are actually risking and how little reward it is. All right, folks, I will see you back here tomorrow. Definitely for the Slightly Buzzed Friday show at 5 p.m. Depending on how busy I am at work, I might produce a video or two about the Faust case, the Faust trial tomorrow. Meanwhile, go check my other stuff. It's good. I promise. Check my videos. I need the views. But let's see here. Who can I release you to or redirect you to? Let's see here. I have Every Day with Jay ongoing. So I'm going to drop you off at Every Day with Jay. Thank you, folks. Remember, hug your family. Unless they're crap, then screw them and give your love to the people who deserve it. See you tomorrow. Bye-bye.